Good morning, everyone. Welcome to another EURES webinar. Today we will be learning about the latest developments in remote work. My name is Eva and I will be your moderator today. So let's have a quick look at what you will hear about today. So first you will hear some updates with regard to the general concepts and tendencies that you should keep in mind when discussing remote work. Then you will also hear about the latest developments with regard to social security legislation and also its status after the pandemic in the whole European Economic Area and Switzerland, so in all the EURES countries. And then lastly, you will also hear some figures and facts about the rise of telework and what impact it has had on working conditions and regulations. Lastly, there will of course be a questions and answer session where we will aim to answer all your questions. And just a quick look at who will be our speakers today. So first you will hear from Professor Gabriel Tavits from the University of Tartu, then Bruno de Pauw from the National Social Security Authority in Belgium will share with you his expertise and experience on the latest developments in social security. And lastly, we will have with us Mr. Oscar Vargas Llave from Eurofound, another European agency. All these speakers, of course, please feel free to post them questions in the chat, and they will answer, or they will aim to provide you with answers to your inquiries in the questions and answer session at the end. Also, the slides that you will hear today, you will receive them via email after the webinar. And now we will go into the general concepts and tendencies with Professor Gabriel Tavits.
So, good morning, everyone who are now watching us. We will start now to discuss the topic that is dedicated to the remote work and especially to the general concepts and tendencies within the European Union. I am Gabriel Tavits, Professor of Social Law, working at the University of Tartu School of Law, but at the same time I have also been involved in different trainings concerning the social security and general taxation issues for those people who are moving between the different European Union countries. And now we are moving on to to the general topic. First of all, we do not have at the moment on the European Union level no concrete definition about the remote work. It seems to be that there is no clear understanding also what does this mean. But at the same time, what we can observe is still the fact that there are still national legislation who have tried to give the definition what is the remote work or telework, depending how we pronounce it. For example, the Polish Labor Code had recently amendments concerning the remote work. Also, for example, Austria has adopted some amendments in the legislation in order to give also the clarification to the notion like what is the home office. And when we look, for example, into the Estonian legislation, then in Estonian legislation, there is no concrete definition. What does this mean, the remote work? It has been only said that in case the employer and employee will agree on using of remote work, then this kind of agreement should be in a written form. So therefore, the situation in that sense is quite puzzling, but at the same time, we can still refer to the so-called general understanding of what does this remote work mean. And now, in order to move on the general understanding, if you look at the general understanding and the definition, what one can see here, then basically saying everything seems to be for us very clear, because when we talk about remote work, it's still work that is not done in the premises of an employer. It is done somewhere else, and basically saying now the question is whether this place where the person can do remote work is agreed between the employer and employee, or employee is free to choose the place by him or herself. And also the location where the person can fulfill his task could be also different. For example, usually there are also so-called shared spaces, especially buildings where the people can just come, switch on the computer and start to work, or there is other places, or we can also say that sometimes we can also call them as a country office, especially in the period of pandemic situation. Then the people were not in the cities, they were outside and countryside, that there is also so-called the home office. So that's why the remote work means that there is a contract between the employer and employee, but when we talk about the exact place of employment, it is not clarified. Therefore, it can be chosen by the employer or by the employee. Main aspect by this remote work is that there is no office space of or such. When we now move on with the general questions today, then when we talk about the remote work and also some aspects concerning the remote work, then we have to discuss basically saying three different points. First of all, the free movement of workers, then questions, of course, about occupational health and safety issues, which is quite complicated by the remote work, and also the general aspect of the employment contract. And when we refer to the free movement of workers, and especially the free movement of teleworkers, then the European Labour Authority is now using the word virtual labor mobility in order to clarify this kind of free movement of workers. And now, when we will discuss more deeply the free movement of workers issues, then we have to look at some certain points that are quite important in this sense. First of all, of course, the people are worried about the taxation issues. Basically saying what we are talking here about is the situation with the income tax, which creates some problems and misunderstanding. But by this taxation issues, basically saying when trying to find out in which country I have to report my worldwide income, and in which country I have to report only the income from my employment, then we have to look at the place of the habitual residence. Basically saying taxation issues, they do not have any link to the country of employment. Of course, we have also the other taxation issues concerning property taxes and so on and so forth, but by the free movement of workers, especially the income tax plays a very important role. And the taxation issues, in order to protect workers, they are solved by the bilateral agreement, which are signed between the different European Union member states in order to make this free movement more attractive to the workers. Then the second point is dedicated to the social security issues, which of course plays also a very important role by the free movement of workers. And especially here we have some connections to the country of employment, not the country of the habitual residence. And of course, this question about the substantial part of activity plays important role. But the social security issues will be handled and clarified in our next presentation more deeply. But in order to give us some general a general overview. Then, in order to find out solutions to this remote work, and especially for this remote work and the free movement of workers, there have been concluded already specific agreements between the countries, between the 2 or 3 European Union countries, in order to clarify how to find out this 25% of the substantial part-time activity. But beside of the single agreements between the different member states, also now the European Union-wide agreement has been prepared, and this European-wide agreement on the social security issues, especially for the remote workers, as I said already, will be explained and handled in our next presentation. Now, when we move on with the occupational health and safety issues, then this occupational health and safety issues is in that sense important because we need to accept the situation whereby the remote work, the employer is not in the position to control everything. And then, of course, this makes sort of headache to the governments and to the employers how to fulfill their task. Because even when we look at the European Union directives, or even if we look at the national legislation, then both of them basically saying have the same statement that the employer is responsible for the health and safe working conditions. In traditional way of working, that's very simple to follow because there is a office space, there is a concrete place of job, and the employer is present, the employee is present, and we can control what is happening. But in case of the remote work, the situation is even more complicated because there is no employer who is actually exercising the control over the necessary working conditions. So so that's why the main question remains how still currently the safe and healthy working conditions. And here some countries, well, basically saying on the example of Estonia, has made slight shift of responsibilities, which means that when this kind of remote work is exercised and the employee is willing to do this remote work, then the employer has to explain what kind of risks this telework can bring with it. And in case the employee has understood what kind of risk there are, then of course also the employee takes the responsibility for the certain accidents that could happen in fulfilling the task. But anyway, these are just some examples how to solve the problem, but the main problem still remains because exercising the control about the health and safe working conditions can be very problematic. Also concerning from the point of view of the protection of personal data. But anyway, at the moment, at least, the main responsibilities is still with the employer by the occupational health and safety issues, and we can still shift the responsibility, but not in a whole way. And then the next point that is still important is connected to the employment issues, to the employment contract. And here we have to look at the different position of this remote work and remote workers, we can say so, because as we already have seen when we talk about those free movement of workers, or this virtual labor mobility, we have already indicated two problems. First of all, the taxation issues, which plays important role by the free movement of workers, and also the social security aspect. It's important one. But at the same time, there is also the labor law point, which is also quite important, because even by the remote work, we have to think about it, what kind of conditions will be applied to the employment contract. Although We have on the European level adopted the directive concerning the transparent and predictable working conditions. This directive does not say anything about the remote work. But at the same time, this directive is still important because it gives the sort of information, especially in Article 4, where the employer has to inform the employee about the employment conditions. So it means that there is an employment contract and still there are conditions that should be clarified to the employee in order to understand what are the rights and obligations of an employee. At the same time, the question is whether the employee understands those conditions. This is very hard to prove, but still, in case there is a dispute, then the employer has to give sort of information whether he or she has informed the employee about employment conditions or not, and in which manner he or she was doing that. So this is concerning. This concerns now the employment contract, but at the same time, we have to still think about international private law issues, because it is not just about the employment contract as such. Because when we talk about the free movement of workers, it is connected to the other countries, it is connected to the other legislation. And so the question is, in case the person is working or outside of his or her country, or is working for the foreign company, then it could be also the question that the employment contract as such will be influenced by the foreign law. And this is now the question of the international private law. We have on the European level, the so-called Rome regulations, which is dedicated to the contractual relations. And according to this Rome regulation, it has been said that by the employment contract, there are basically things, four different options in order to clarify what kind of legislation is applicable. First of all, the parties to the employment contract can agree by themselves what kind of law is applicable. For example, is the Spanish law or the Portuguese law or Estonian law? That's the first thing. The second thing is, in case we have not agreed what kind of law is applicable, then of course we will apply this law, and this is now important for the remote workers. Where is the habitual place of employment? The third one, in case the habitual base of employment is very complicated to find out because people are moving, then of course we have to look at the legislation where is or was the place of business that hired these people, of those people. And in case it is not possible to find out whether there is a place of habitual work, or where there is the place of business from which the person was hired, the very general possibility is that the most closest legislation will be applicable to the employment contract. But anyway, in order to avoid any complicated issues and any problems, it is quite good, or it is advisable that basically saying the people agree in the employment contract what kind of labor legislation will be applicable, and especially by the remote work, this plays really important role. Because by the remote work, the habitual base of employment is very easy to clarify, because usually the people are sitting, at the table in the same country, and this means that this law is applicable. But it could be that maybe this law is not the most favorable, and then of course the parties by themselves have to think about it, what kind of law they will choose. Anyway, the practical problem here is when we talk about this, especially free topics, taxation issues, social security issues, and labor law issues. is the fact that especially the workers, they do not pay any attention to this subject before they will leave the country. The main aspect for them is how much I will get outside of my country, or how much I will get into my bank account. But afterwards, when the problems will appear, then they start to think what is the tax residency issue for me, how still the social security can be determined, and what kind of obligations I will have from my employment content, what kind of legislation is applicable in that sense. Because, for example, this employment law issues is also very directly connected to the dismissal law, which is very sensible area of the employment law. And of course, the dismissal rules within the European Union could be very different. Although they are also applying for the remote work, still we need to clarify what kind of legislation is applicable, because then we can also see what kind of conditions has to be fulfilled. Also, for example, those conditions are connected to the working time, vacations, and everything, also those detailed aspects. And so, in order to now summarize the general tendencies, what we can say is the fact, first of all, on the European Union level, it seems to be there is no general understanding of the remote work at the moment, at least, or legally binding general understanding. That's the first thing. Second thing, when we talk about the taxation issues, it is still resolved between the member states, especially using the double taxation treaties. Social security is one area where we have the European Union rules, and it seems to be that there will be more clarity on that point. And when we talk about the employment law issues, still the national legislation will give us the definition, what is the remote work, and also the necessary conditions. For us, when we are moving within the European Union, is now important to find out what kind of legislation is still applicable and what is the more favorable for the workers. So there are different issues that we have to solve, and so far we have done it quite well on the European Union level, but there is still a way for the improvement. So thank you very much for your attention, and we will see again in the question and answer session.
Thank you, Gabriel, for sharing with us the observations about general concepts in remote work. Now we will go on to the presentation by Mr. Bruno De Pauw, who will take you through the latest applicable legislation and post-pandemic cross-border telework in the European Economic Area and Switzerland with regard to social security.
Good morning, ladies and gentlemen. I am Bruno De Pauw from the National Social Security Office in Belgium, and we'll discuss today the topic of cross-border telework, with a special attention to the new agreement which has been reached in these cases. Voilà. What will we look at today? Very shortly, a recap. The European conflict rules for cross-border working. Then a period in the past, and still now a current period, what is called the COVID-19 and the transition period. Then we'll have a look at the main body of our presentation, which is the so-called Framework Agreement Article 16, and we'll end with other forms of telework, which do not fall under the scope of the framework agreement, but might be received favorably by the member states. So first, a little recap. The European conflict rules on cross-border working. So as you know, within a large area comprising many countries, these European regulations with a horrible name, 883/2004 and 987/2009, are in fact applicable. This is within the countries of the European Economical Area and Switzerland. Just also a little recap, European Economical Area, this is the EU member states, 27, plus Iceland, Liechtenstein, and Norway. The main rule, so which member state is competent in case of cross-border work, is the lex loci laboris rule, which means the law of the place of work. This means the place where a worker is physically present during the exercise of his professional activities is competent. An exception, temporary exception to this rule, is the posting, which is an employer which sends on his behalf an employer temporarily, maximum 24 months, to work for him in another member state whilst remaining under the authority of the employer. Posting means that not the legislation of the member state where the person works is applicable, but the legislation of the sending state. Self-employed persons can post themselves. But the rule that interests us even more is the working in multiple states rules, which means it is part of the normal, anticipated, and regular working pattern of a person that he is going to go often abroad. So it's clear that the place of work, as described classically in the work contract, is not limited to one state, but to several states. For example, a person working in the area of construction that often has to go work on a building site in another member state, or a manager of a company that undertakes 30% of his time business travel to another member state, for example. This rule, for people having only one employer, which is the largest group, is in fact what is called the 25% rule. This means if this person works 25% or more in this member state of residence, then the member state of residence is competent. If it's less than 25, it is the member state of the seat of the employer. Seat means the registered office of or place of business of the employer. It's 25% of the working time, which is the regular criterion, and the remuneration. This 25% is evaluated over a 12-month period. In principle, a future 12-month period, in the sense that you have to know in advance which Social Security applies, so where contributions have to be paid and where the Social Security coverage is served. There's also in this chapter some more complicated rules. What happens if you have several employers? And also the mixed qualifications, which means if in certain member states you are self-employed and in others you are employed or even civil servants. I will not discuss today the multiple employers and the mixed qualifications, only the classical case of an employee having only one employer. Now, let me take you back a bit, more than 2 years, the start of the COVID-19 pandemic, which hit everybody like a hammer, even us. Nothing happened until March 2020, when all of a sudden there was this big outbreak, there were lockdowns, and in fact the normal way of working cross-border was seriously hampered. This means that people having a job at that time, which was teleworkable, so which could be done not from the office but from home, had to work from home. What happened? Already very soon, special decisions were taken, which were called the COVID-19 neutralization or no impact measures. And this was in fact a juridical trick based on what was called force majeure, that the change of place from which you work, from the office to home, would not have an impact on applicable legislation. Which means if all of a sudden you worked 80% from home, and before you commuted every day to your working place at the other side of the border, so 100% in your employer's country. Normally 80%, more than 25, switch to the social security of your resident state. No, we said, because employer and employee cannot decide freely on the place of work. There are lockdowns, obligations, or even further down the road, very highly recommended telework. So we said, let's freeze the situation and keep the member state that was competent before the outbreak in March 2020 as the competent state. Now, these decisions in Belgium, they were already taken very early, but they also amounted up to the Administrative Commission, the European level, where this was confirmed by decisions in 2020, 21 June, and then end of 2021, because of the ongoing effects of the pandemic. This was called the COVID-19 neutralization period till just before last summer holidays in 2022. Now, in the meantime, this was already a long period, employers and employees said, we kind of like this hybrid form of work which has developed over time, partly from home and partly at the office. Secondly, there came pressure from the basis up, from employers and employees representative organizations. Hela, this 25% limit is hindering us, is an obstacle, because the workers want to work from home at least 2 days, 40%. And we as an employer, we don't want to pay social security in another member state. Because for small countries like Luxembourg, this would mean that one Luxembourg company could have a payroll in 3 or 4 different countries. So pressure was exercised. And then, unfortunately, it was not possible to use force majeure again, anymore, because, well, the COVID pandemic had no longer such strong effects. That's why a decision was made to create a transitional period. Transition between COVID and business as usual. And what was the aim of this transitional period? First of all, to examine, hey, the classical rules, the 25%, the posting, how do they apply in relation to the special form of work, which is telework? And secondly, are these rules still opportune? Do they still achieve the desired effects, or do they constitute a kind of obstacle? To imagine these situations and to examine and propose new rules, a specific group was created, which was called the Ad Hoc Group on Telework within the Administrative Commission. I have been appointed rapporteur for this group. Now, okay, interpret and change. If you want to change, what are the legal possibilities to change? What did we see? That quite some employers created 2 types of telework policy. And they said, employees residing in the country where I am established, they can telework 2 days, but employees residing in another member state, only 1. Different policies. Major question, whether this would not be an unjustified discrimination. Or perhaps we could simply change the rules of the game by adjusting, updating the European regulation themselves, like the 25% rule. But if you know that these regulations are the object of an update, trying to achieve an update already more than 7 years, then you know this is not very realistic. Or perhaps we could use Article 16, which gives the member state the possibility to derogate from the other rules and do it in each individual case. Also not easy, case by case. Or should we conclude a framework agreement, in a sense, come together and make a common understanding and a common procedure. Now, this administrative commission mandated for all of that the ad hoc group on telework. And the task of this group was to create a definition of telework, a uniform interpretation of the conflict rules, and propose a specific rule to change the regulation with. Normally, such an ad hoc group, it's 10, 15 people, experts from the member states. But this created a very high interest for many member states, and we were a group of 42 experts representing, emanating from 20 states, even including Switzerland, Liechtenstein, and the United Kingdom. We had not much time. We started in September last year, interim report in November, and our final report was delivered the 17th of March 2023, and end of March it was discussed and adopted in the Administrative Commission. We also got an extension of the mandate for this new European rule till the end of next year. Now, more practical. What did we do and why? First of all, our starting point was that the actual rules as they existed now were not necessarily opportune for the specific situation of working that telework is, because telework is work that can be undertaken from anywhere in Europe. So this means the link between the place where you are, from which you telework, and the country in which you are is way less strong than location-based work, which is you work in that state because you have to be there, because you have to be with your colleagues, you have to negotiate with the client, etc. So we said, starting point, telework is indeed different than location-based work. Secondly, for whom are we going to create something special? Well, we've seen that everybody had changes in their work pattern through COVID, but the group that was most impacted were the classical, what I would call frontier workers, meaning residing in a member state, employer's premises in another member state, and commuting back and forth every day. This group had the largest and the most lasting impact. So we say, let's focus on this group, the frontier workers. The guiding principle which we used was to diverge as little as possible from the existing conflict rules. Why? We did not want to take the place of the legislator, because this is for a new rule, but just derogating with Article 16, and as not to create what is called a democratic deficit, we said, let's stick as closely to the existing rules and diverge as little as possible. Special attention was paid to provide legal certainty, a clear black and white rule, so as much interpretation and clearness as possible. And of course, we had to avoid unintended consequences because we did not want, of course, this new proposal to be abused for objectives other than the protection of the teleworkers. Now, the agreement in itself. Let's have a look at this. First, we started, as usual, with the definition. And the main characteristic of telework, which distinguishes it from all other kinds of work, is that it's location independent from anywhere. Of course, the teleworking has to be cross-border, so it is teleworking that is pursued outside of the member states of the seat of the employer. And we added another element, which is not necessarily for telework, but to delineate the group, to limit the group. We said we do not want this rule for manual telework, only for digital telework. So we said one element in our definition, what we are going to use for Social Security, is that there must be an IT connection between the teleworker and the environment of his employer. So only the digital ones. First, for this group, all the teleworkers, we examined, hey, these regular conflict rules I've talked to you about, posting and multi-state, how do they work on telework? And can we be flexible? Do we need something special? Or can we simply, with interpretation of the existing rules, already solve the problem? Now, for posting, we arrived at a compromise because there was a discussion. Is the posting rule, so this means the temporary, occasional work abroad, normally this is at the initiative of the employer. The employer is going to send somebody. Do you allow me, employer, to work from my holiday home during a week? And if yes, is it then a posting? This was agreed, being that even telework at the initiative of the person could still meet the posting condition, which means this person remains covered in his habitual state, and the employer simply can continue to pay contributions in the habitual state. The only thing you have to do is to request an A1 form, so the certificate on applicable legislation, like any other type of posting. The multi-state rule gave rise to way more discussions, because in the regulation it is mentioned the 25% threshold, but it says that the 25% is an indicator in the context of an overall assessment, whatever that might be. And we clearly saw that some experts said no, 25% and nothing more or less than that. And other experts says, we are a bit flexible, up to 5% less or more. So between 20 and 30. Anyway, even though we did not reach a sufficient majority, it was clear that as the employers and employees representatives wanted 2 days telework a week, this amounts to 40%. And it was not possible to interpret, to stretch 25 to 40. This was clearly overstretching the legislation and not possible. So the conclusion was, for this group, we need something new. And what did we need? Well, Article 16 provided a solution, which was, and I've put the article here, member states may, on request, make exceptions to the conflict rules in the interest of persons or categories of persons. What we made was a model of a policy agreement. Why model? Because every member state agreeing with it has to sign it. Why policy? Because it creates a policy, in a sense. In these conditions, I will accept a request, and in these conditions not. It's not an automatic rule, which means I, member states, that are going to sign the model agreement, I will honor each and every individual request that is submitted to me. Why is this special? Because in general, member states have the discretionary power to accept and not to accept. And here the signing member states limit, fix their margin of maneuvering. It is clear that each situation that does not fall under the scope of the framework agreement, the normal rules of Article 13 of the regulation will be applied. And it is a request, which means it is a choice that has to be made in consent between the employer and the employee. In general, it will be the employer that makes the request. The employee can also do, but anyway, it must be following a discussion and a consent between those two parties. The scope, which persons, which situations fall under the framework agreement, it is only employees working in the employ of one single employer. Or, but it is not very frequent, several employers which each have their seat in the same member state. And secondly, as concerns the working pattern, it is only for people that work in the member states of the seat of the employer and in their member state of residence, only telework. So imagine you telework in your member state of residence and you visit clients regularly, you fall outside the scope of the framework agreement. The rule in this framework agreement, now that we've seen the scope to whom it applies, it is you need to work less than half of your working time in the member state of residence, which implies that you must work more than half in the member state of your employer. So 50-50 is out of scope. This means the maximum you can work in your member state of residence is 49,999, not 50. This is evaluated over a period of 12 months. The mechanism is, it is on request, and it must be requested in the member state of the employer, because you want to make this member state competent. So the member state of employment receives the requests, checks the conditions, and if it falls within the scope of the framework agreement, issues immediately an A1 certificate, so attesting the exclusive competence of this member state. The duration of this A1 is at the discretion of each individual member state and can vary between 1 and 3 years. Belgium, for example, is highly robotized. And in fact, we will only issue A1s for 1 year. Probably the member states with many frontier workers, Luxembourg, Switzerland, etc., will issue documents with a longer validity period up to 3 years. Now, this member state of residence simply has to inform the member state of employer, which issued the A1, only has to inform the member state of residence. So the member state of residence does not have to take a decision like in the normal process of an Article 16 exception. In other words, this should go swiftly. Entry into force of this agreement will be the day after the end of the transition period, which is the 1st of July of this year, which means next month. For which member states? For the signatory states. In fact, on the website of the Belgian Federal Public Service will be mentioned each and of the member states. So I could already inform you that Belgium, the Netherlands, Germany, Austria, Czech Republic, Finland, Malta, Portugal, many member states have already or signed or announced that they will sign before the end of the month. Only one member state has officially said, no, I will not sign, which is UK. And one member state keeps us guessing, and it's France. So for the moment, we don't know yet what France is going to do. For latecomers, so member states that will only sign after the 1st of July, this will enter into force the first day of the month after the signature. So if a member state signs, let's say the 1st of September, it will enter into force the 1st of October. Now, this is the list which of the member states which have already confirmed as of today and the unlikely ones. Okay, after all of this theory, some practice to make sure you visualize exactly who will fall under the scope and who not. I've created a number of cases which will make it clear. And we start with Adelheid. Adelheid is employed full-time by Volvo in Belgium and wants to work 2 days a week from her home in the Netherlands, and this for an indefinite time. So we check how many member states are involved. The Netherlands, where she lives, Belgium, where her employer is situated. She does not work in other member states. How much does she telework? 40%, 2 days a week. Voila, the conditions are fulfilled. And if her employer or herself, she submits a request to the social security institution of the member state of the employer, Belgium, Volvo, we will issue an A1 confirming the Belgian social security. Or in other words, Volvo can allow Adelheid to work 2 days from home without any influence on the social security, and Volvo can simply continue to pay social security contributions for her in the Belgian scheme. So everybody happy. Albrecht, however, works in Strasbourg, France, at a French branch of an Austrian company. He teleworks from his home in Germany, Mittelhausbergen, 40% of his working time. Hola! This does not enter the scope of the framework agreement because he works in France, not at the seat, the statutory seat of the company, but simply at the branch. This means 3 member states are involved: Strasbourg with the branch, Austria with the seat, and Germany with the residence. This does not fall under the scope of the framework agreement, which means 40% from home, German social security will be applicable, and in fact the company will have to pay into the German scheme. Amber. Amber resides and works in Brussels. And Amber has always dreamt about the Nordic countries. And now she thinks this is the perfect time. And she goes to the HR department and she asks the permission to go on a 4-month trip to the Nordic countries. And she says, I understand it is difficult for a job, but you know what I'm going to do? I will work remotely from wherever I am at that moment, hotel room, hostel, tent, whatever, on Mondays, Wednesdays, and Fridays, and I'll take holidays on Tuesday and Thursday. Hey, HR department, do you agree? Now, does Amber fall under the framework agreement? Absolutely not, because many countries are involved, all of the Nordic countries. But this is a classical case of Article 13. We take a reference period of 12 months, and it's clear in the 12 months that she will work more than 25% of her time in the 12 months in Brussels, where she lives. This means Belgian social security. This means employer says no problem, because I can continue to pay Belgian social security. She, in fact, or her employer has to let the Belgian authorities place of residence inform, and we will issue an A1 document based on multi-state working, confirming Belgian social security. Antonia lives in Belgium and works for a Belgian employer, and she takes 2-week holiday like each year in Spain, and she will work subsequently for 3 weeks remotely from her grandparents' home in Spain. Does she fall under the framework agreement? Absolutely not, because this is not habitually teleworking. This is occasionally teleworking. And if all of the posting conditions are met, which is very probable in this case, Belgian Social Security will continue to apply during the 3 weeks teleworking from her grandparents' home, and the Belgian company will be happy saying, okay, nothing happens for me. I can still continue to pay Social Security contributions in Belgium. I just have to request an A1 certificate like for any other posting. Jean resides in Hasselt in Belgium and works for a Dutch company established in Maastricht. And Jean delivers parcels in the Netherlands with a company van. And he also has for the same employer another task for which he works 30% from home. And what does he do? He has the job of administrative support of the company. It's a small company. So in the country where his employer is established, Netherlands, he drives around his van, his truck, and in Belgium he teleworks, but for a completely different job. Does he fall under the framework agreement? Yes, because the framework agreement does not necessitate both activities to be the same. Secondly, the framework agreement does not necessitate that you work at the seat. You only have to work in the country where your seat of your employer is established, not necessarily at the seat or in the office of your employer. So this person, and that might surprise you, does fall under the framework agreement. So an Article 16 agreement may be submitted to the Dutch colleagues. Katarina resides in Czech Republic and works for a Slovak employer. She habitually teleworks from a co-working space close to her home, about 40% of her working time. But she teleworks from home during the summer holidays way more than 40%. If we take the full period of 12 months, she teleworks 48% of her working time. Does she fall under the rules and scope of the framework agreement? Yes, because over a year period, it's 48%, so it's less than half. And there is no problem that it varies during the year. We take the full period of 12 months. Secondly, in her state of residence, she works from a co-working space, but she can telework from whatever place she wants. A cafe, a park, a co-working space, etc. Of course, provided that this co-working space is not full of colleagues of Katarina that reside in Czech Republic, so that it once again becomes an activity where you interact with your colleagues physically, because then the main characteristic of telework, being location independent, is not fulfilled anymore. But in principle, yes, the case of Katarina can fall under the framework agreement. And then we have Herman. Herman resides in Vienna. I made a typing error, which is of course Austria or Belgium, and works for a Slovak company established in Bratislava. He works 40% from home, but he also, on top of that, pursues a small self-employed activity in Austria during the weekends. So unfortunately for Herman, he falls out of the scope of the framework agreement because of his additional self-employed activity. Ilka resides in Germany and works for a Swiss employer. She habitually teleworks from her home 40% of her working time, but she also regularly and in an anticipated way undertakes business travel to clients in France for 7% of her working time, which means she habitually works in 3 countries, Switzerland, Germany, and France, so she falls out of the scope of the framework agreement. Jacob resides in Oslo, Norway, and works for a Norwegian company. He travels to Nice for 3 weeks holidays and subsequently teleworks from his hotel during 2 weeks. So, is it framework agreement? No, but it is an occasional telework. And in fact, if the posting conditions are fulfilled, which is very probable, he will continue to be covered as a posting under the Norwegian Social Security scheme. Sylvia resides in Switzerland and works for a Liechtenstein employer. She habitually teleworks from home 40% of her working time, very well. But what happens now? She needs to attend a 5-day conference in Paris. So thus, an occasional, exceptional activity in a 3rd country, France compared to Switzerland, Liechtenstein, does this invalidate the framework agreement? No, it does not. Regular and habitual work in a 3rd state invalidate the framework agreement, not exceptional, occasional, and short-term work in a 3rd state. Voila, this gives a bit of an overview of practical cases which will help you to exactly know when we're talking about posting, when we're talking about framework agreements and the possibility to submit a request. And now we're passing on to some procedure elements. Article 16 requests and retroactivity. As I've already mentioned, consent of employer and employee is necessary. And as concerns the time frame, the starting point and principle of the framework agreement is no retroactivity, which means only for the future, which means that if you submit a request, the starting date of the requested period must be in the future, not in the past. Except you can submit an application for a period which started in the past if some conditions are fulfilled. The main condition that needs to be fulfilled is that the contributions in the past period you're requesting have been paid and coverage was in the employer member state. Okay, this is a starting condition. And then we're talking about 2 types of periods. Normally, you can go 3 months retroactively, but starting the agreement 1st of July of 2023, so next month, we have created an initial startup grace period from a full year, which means any request submitted during that period, going back in time even to the 1st of July this year, will be accepted. Once the startup period has expired, it's only 3 months retroactive that can be requested. Now, after this theory of retroactivity, a practical example, we take Jean, resides in Belgium and is recruited by a German employer. His job starts the 1st of September of this year. He will telework at home 40% of his working time, and the German registered him in the German scheme, starting so the 1st of September, but he only learns of the agreement and files the request on the 1st of April. Now, 1st of April is within the first year, July till the end of June. So this means this will be accepted. And the framework agreement will be applicable on Jean starting the 1st of September of this year. So no issue with the retroactivity because we are in the first startup year. And secondly, contributions have already been paid in the correct scheme, which is the scheme of the employer. Miloslav resides in Slovakia and is recruited by a Czech employer, also starting the 1st of September of this year. He also teleworks from home 40% of his working time, but the Czech employer has registered him in the Slovak scheme. So the normal rule, 40% substantial in the country of residence, so country of residence is competent. And he learns of the existence of the framework agreement only later on. And he says, well, I'm going to try to get it. And on the 25th of November of this year, so within the first year, he does file a request for a period starting the 1st of September. This will be refused because he has already paid Social Security contributions in the member state of residence. And the framework agreement does not have the effect of switching retroactively from Social Security scheme. So remember, extremely important for an employer, even before filing the request, pay contributions in the correct member state, which means your member state where you are established as an employer. Now, luckily, most employers also do this because they are, of course, familiar with this scheme because all the rest of their personnel is registered in that scheme. Now, there's also, we've seen and we've heard a lot of conditions. What if one or more of these conditions are not fulfilled? You have 2 employees, you have an additional self-employed activity, you are late for your application. Well, you can still file a classical Article 16 application, which will be outside of the framework agreement. But this case will undergo a case-by-case assessment by the member state of the employer, where you have lodged it, but also by the member state of residence. And it's only if those both member states agree that an Article 16 agreement will be concluded. Will this be often accepted? I think not. And how much time will this procedure take? A lot of time. So creating a kind of long period of juridical uncertainty. Why? Everybody, all the administrations will of course be swamped with applications. A country like Switzerland has 400,000 frontier workers. You can imagine. And the agreement starts in the middle of the summer holidays. So everything that falls under the scope, rest assured, this will be agreed. For the cases outside of the scope, it's a question mark. So at the end, the takeaway. What does an employer have to remember? First of all, draft a telework policy. What is acceptable for me as an employer and what is not? Agree with your employees. And of course, create a system to actually track your employees. Know from which place your employees are working. To our experience, this is not exactly always the case. Many employers, HR departments of the employers, have no idea where their employees actually working. So make sure this is done. Secondly, watch out. Ask your employee whether or not he has additional activities outside of the work he's performing for this employer. Does he have an additional self-employed activity? Does he have an additional employed activity, for example? Many many employers never ask this question. Do ask the question because it is very important to know whether or not this falls within the scope of the framework agreement. And of course, from the 1st of July, but you have a whole year, so do not feel the need to rush. From the 1st of July 2023, you file an application or a classical application of the 25% rule, because you like the 25% rule, and this application must be made in the member state of residence, or you file an application, Article 16, which is based on the framework agreement, and this will be in the member state of the employer. Voila, this is the end of a short overview of the framework agreement. Will this answer all of your questions? Of course not, but there is a possibility for discussion and additional questions, of course. Thank you very much already for your continuous attention.
Thank you, Bruno. Just to remind our viewers that you may ask questions or already in the chat, and they will be answered in the question and answer session after our last presentation, which will be about the rise of telework and its impact on working conditions and regulations. And presentation will be presented by Mr. Oscar Vargas Llave from the Eurofound. So please, Oscar, take it away.
Hello, my name is Oscar Vargas Llave. I'm research manager at Eurofound. Eurofound is one of the European agencies of the European Union. Our focus, our objective, our remit, it is to provide evidence-based research to policymakers, particularly to the European institutions, the Commission, the Parliament, the Council, but also to the social partners at EU level. On top of that, we also provide our research to, and is available for all social partners and governments of the 27 member states. My area of work, it is mainly working conditions. I also address issues related to industrial relations because many times they are very close linked to the topics I address. I'm mainly now working more on the area of digitalization, telework, hybrid work, and the impact of these changes on working conditions. And this is what is going to be about my presentation. It's going to be about the rise of telework and the impact it has on working conditions and regulations. So I will share the presentation. So as I said, I'm going to start explaining what is the impact of the expansion of telework. First, I'm going to give you an idea of how telework prevalence has changed, during the pandemic and after the pandemic, and what could be the likely future of this form of work, how prevalent will be, etc. In the second part, I will address very specific aspects of working conditions, mainly in relation to working time, how this way of working is modifying our working time patterns. And also, finally, I will give you some highlights about how it's regulated telework at EU level, with some developments at member state level, including, for example, the so-called right to disconnect across the years. So in this slide, you can see in the gray line the actual evolution of telework. The indicator here is the share of employees teleworking. As you can see, from 2012, we already see some increase, a slight increase in the number of employees teleworking, and we clearly see that since 2019, 2020, there was a huge jump in the curve. I put together also another couple of lines. One represents the estimated increase if the growth rate of telework would be the same as it was experienced in 2019. You see that then we will have reached the same level as in 2022 in 2026. So some years, before we reach the level we have right now, for example. But if we consider the average growth rate for the full period between 2012 and 2018, we wouldn't have reached this level of persons, workers teleworking until 2035. So this is to give you an idea that the magnitude of the change in very short time. It's also interesting to see not only that is how is growing telework, but also what are the differences between countries, because there are huge difference between the EU member states. In this slide, you can see that also the growth by country, since 2018, but there is more interesting to look at the differences between countries. So the EU level in 2021 was 22%. I can tell you now that with the latest figure from 2022, there has been a small decline, but very small. So still we are around 20% of people teleworking in the as an average in the European Union. But let's go back to my main point here, which was the difference between countries. It's very clear that we see a pattern across the years. So this is not new. That was happening before the pandemic, these differences. For example, we see clearly that the Nordic countries and also the Benelux are countries that have always had a relative high percentage of employees teleworking. It has to do, of course, with many issues that are going to develop a lot now. It has to be with the flexibility in the labor market, in the way they organize work, the culture of work, the level of trust in companies, but also the way it is regulated, telework and work in general. Whereas we see that in Central Eastern member states, mostly, and there are exceptions, of course, here in generalizing, the rate of employees teleworking is rather small. Even after the pandemic, we see that the increase, they don't reach more than 5%, for example, in Bulgaria. But it's also important not only how many are teleworking and the differences by country, but also with what frequency we telework. I'm pretty sure you have heard a lot about different terms when it comes, working flexibly in terms of place and time. So you have heard very likely remote terms like a remote work, telework, of course, flexible work, also hybrid work. So the different terms used, and it's very important to reflect about this. And sometimes these terms, like a hybrid work, the only point that is raising is that combines both working from home and working from the workplace. So it relates to the frequency they telework. So we, in this sense, we developed this classification. We group workers according to the frequency they telework. We have occasional teleworking, so those who only telework sometimes. Then we have partial telework, which are workers that telework from the office and also outside, but not frequently from home, more from other places. And then we have those which we can call hybrid work in light orange, which are the workers who work from both places only, home, the office, and those working full time. So this is the picture for 2021. I know there's a lot of, we are in 2023. However, the distribution of workers according to the frequency that telework has not changed much. The large majority is doing either occasionally or in a hybrid mode, and there is only a relative smaller proportion working only from home. And this is a trend that is continuing. We see that in the latest figures, there are more people working occasionally from home, less people working frequently from the office, from home. But having said this, also I would like to mention that all our surveys show that the preferences of workers mainly is to work in a hybrid mode. So it is important also to understand what's going on. I said that at EU level, telework has a slightly decline after, so there was an increase in 2021 during the pandemic. It was also an increase in 2022, where most of the restrictions were already lifted, pandemic-related restrictions for movements and working at the office, but there was still an increase. And we saw in 2021. Last year, what we saw was a slight decline. So it is a decline that we expected. But also, as we expected, we are not back to the same level of telework as we had before the pandemic. We can see this clearly in the next slide, giving the example of Spain. Okay, we see in yellow the percentage of employees teleworking in Spain in 2019. So very small, or 4%, and then suddenly in the second quarter of 2020, jumped to 17% in red. Okay, you see the red bar, and then you see the evolution across the different quarters of 2021 and 2022. And what we see is sort of, let's say, stabilization. At some point, of course, it has been reduced from the, the red point in second quarter 2020 to the third quarter in 2021. There has been a reduction of employees teleworking. But what is interesting that for the last, let's say, year and a half, it has not declined much. As in the European level, a slight decline, but we see some sort of stabilization at a certain level, which is something between what happened before the pandemic during the pandemic. So you might hear this question before: is telework here to stay? We have seen different opinions, but the fact is that it is here to stay. But a certain level between in the middle between what happened before the pandemic and during the pandemic. Probably it's also of interest for you to know in what sectors telework is more prevalent. Clearly, in those sectors where the use of ICTs is more common, is where you find more employees teleworking, also more office work, work that allows some flexibility in the place, so there's no need to be all the time at the workplace. So this is very clear. And we see that at the top are information and communication technologies, extraterritorial organizations. These are embassies, international organizations like the European Commission, the UN, etc. Followed by education, also important number of employees teleworking in the financial and insurance sector. Whereas, of course, in those sectors where telework is not possible, there's only a few number of workers teleworking. We also have seen across the years that there is a high correlation, at country level between the percentage of employees teleworking or using ICTs outside the employer's premises at different frequencies, and the percentage of workers who are able to work, have some flexibility in the working time, can adapt the working time, can start earlier or later, can also take, for example, 1 hour off to do some personal issues, etc., who are able also to modify the daily working hours somehow, with autonomy. We see this correlation, and it's very high correlation. So in those countries with higher flexibility, we also see higher percentage of employees teleworking. But this phenomenon, this flexibility, and the fact that they are able to telework has also an impact on several issues related to working time. For example, those who work more from home are more likely to report that they work long hours. Also, those working in a hybrid mode, they are also more at risk of being contacted outside working hours by the employer. Some of them might have problems related to the blurring of boundaries between work and personal activities. They tend to work more in a free time. So because it's not only because they are more likely to work longer, but also because they are able to organize their working time, as I said before, so they can in a standard employment would be considered rest time. Some workers, because they modify their activities, it is possible that, for example, during the night or the evening, where in a standard job might be considered a rest period, the teleworker sometimes works, and that's why we say they work also in a free time, okay? Because otherwise will be free time. And also they have less time between a working day and so they don't have enough rest periods between 2 working days. They are more likely also to experience this. These are all taken as generalizations. So, I mean, they are more likely to experience this than workers only work in the office, but it doesn't mean all are experiencing these problems, okay? But we can see here how many really experience some of these problems. In this slide, we see that those working in a partial telework or hybrid work, we have up to almost 50% that they say at least several times a month they work in a free time. Okay, compare these figures with those. I will use the pointer. With those working at the employer's premises. Even those working with ICTs and working at employees' premises are less likely to report working in free time, but also less likely to report that they work overtime. Okay, this is another risk, and this is very clearly also, and this is of course related to what I mentioned before. They're more likely to work long hours, but also overtime. Overtime here is understood as the time you work beyond the contractual working hours. Okay, so here you see the percentages of people doing that under different arrangements. And we look at these issues also from the national country comparison perspective. We look at overtime, and we compare teleworkers, or when I say teleworkers, also, as I said before, is teleworking with different frequency. Could be sometimes, could be full hybrid mode, etc., or only from home. When you compare them to the national average, looking at the percentage of those working overtime, we see very clearly that in all member states, teleworkers, there's a higher percentage of teleworkers working overtime. Here I want to make a point also, because we know that not all teleworkers, the fact that telework does not directly give you flexibility. But in general, there is a relative high percentage of them of teleworkers that have this flexibility. Okay, and because of that, we see in this graph that those workers that reporting problems with work-life balance. Okay, and we see that, for example, those working at employees' premises, only 20% report problems with work-life balance. When you compare this to full-time teleworkers, it's half, only 10% report problems with work-life balance. So telework is good for work-life balance. However, we see that the difference with women is not that high. Okay, we see, for example, those working at employees' premises, even with without teleworkable job, is 17%, for example, compared to 14% reporting problems. Okay, with work-life balance when they full-time telework. So the difference is smaller, which means that the conclusion of this graph is telework in general contribute to improving work-life balance. However, this increase of better work-life balance is higher for men than for women. So both take advantage, and have a positive consequences for work-life balance while they telework, but more men than women. So at EU level, we had a framework agreement of telework signed in 2002. So still this framework agreement signed by the social partners is valid. We also have the 2022 social partners framework agreement on digitalization, which, for example, includes aspects related to help workers to disconnect. Then we have in 2021, and Eurofund contributed with our reports to this initiative. The European Parliament initiative for EU legislation on fair telework and the right to disconnect was approved by the European Parliament, which meant that the European Commission had to go back to the Parliament and decide whether there's going to be a legislative initiative or not in a form of directive. And the Commission decided that it's up to the social partners to negotiate a new legislation on telework and the right to disconnect. And if they fail to have an agreement, then the Commission will decide what to do. But if they reach an agreement, there will be a new directive on telework and the right to disconnect in the European Union. The negotiations started last year in 2022. We were there at the kickoff meeting, just presenting some of our findings, and they are still currently negotiating. If there is no changes in the timeline, by September, negotiations should have been finished. Most of the countries have some type of regulation on telework. Most of them, not all, but most of them. And normally this is based or is aligned somehow with some of the content of the social partners framework agreement on telework that I mentioned before. It was in 2002, not 2022. Okay, so this is what is currently happening. But because of the pandemic, we found that 13 countries have adopted or passed new national level regulation in a form of legislation or social partners agreement on telework. Since the outbreak of the pandemic, we have these countries: Spain, Portugal, France, Luxembourg, Belgium, Netherlands, Ireland, Austria, Slovakia, Latvia, Greece, Romania, and Poland with new regulation on telework, and that was because of the expansion we saw. In our first slide of telework, they thought, oh, we have to do something. And the next slide, we see what issues are regulated when it comes to address telework as a form of work organization. And their working time, normally providing more flexibility to workers teleworking, health and safety, so how to address risk prevention when people telework, the issue of access or request to telework, what are the conditions under which workers have to can telework, and then the costs of teleworking in terms of coverage of electricity or energy consumption at home, etc. And I'm going to finish my presentation with the right to disconnect. In some countries, well, it was first in France. There was legislative initiatives to address some of the issues I mentioned before. Working long hours, being contacted after working hours, working in a free time, apart from not being, let's say, sometimes legally accepted that you work in outside standard working hours, contractual working hours. Social partners saw that there was also an impact on the health and well-being of workers, not to mention work-life balance, and that's why they had these initiatives on the right to disconnect. So, as I said, the first country was France. In the situation in 2018 was these 4 countries had the right to disconnect: Belgium, France, Spain, and Italy. If you want to ask later more specific situation of these countries, you can do that. But after, you see the change, from 2018 to 2022, when we had the pandemic. We saw how the number of countries with the right to disconnect in the legislation, in the regulation in general, has increased. But in the next slide, we see that there are differences in the way it is implemented. I'm not going to develop, but mainly, for example, France, Spain, and Belgium encourage social partners to negotiate at company level the terms under which workers can exercise and implement the right to disconnect, whereas in other countries it's more open, it is in the legislation. But in general, this is the approach, okay? There's a national level legislation on the right to disconnect, encouraging social partners at company level to reach an agreement on this topic. So thank you very much. I have finished my presentation. You can find all these findings in this report. It's available on our website, the Eurofound website. So thank you very much.
Okay, hello everyone. I hope we can hear each other. I also hope that we manage to get everyone into the picture. Yes, thank you. Maybe perhaps if I could ask Gabriel to also turn on your camera, and perhaps if you could say a few words to make sure that we hear each other, and if our participants or our viewers could also indicate in the chat that they can hear us.
Good afternoon, everyone. Can you hear me? Can you see me?
I can hear you. I'm hoping for also our viewers to confirm in the chat that everyone can hear us. I don't see any comments in the chat. I hope that everything is okay. If not, then please, our viewers, I hope you will let us know. So first of all, thank you all for your very interesting inputs. I see that in the chat we do have a few questions. Perhaps to start with one request, and that is towards Bruno. There was a request in the chat, but also I received an email asking whether you could add to your presentations also to the examples that you were sharing the answers to these examples. If it would be possible, please, you can either write in the chat on YouTube or you can unmute yourself here in the Teams and you could let us know.
Hello, everybody. The answer to that question is very simple. The answers are in the slide set. So a slide set in PowerPoint also has possibilities for notes below the slides.
Okay.
And the answers are already in the slide.
Okay.
So if you print it in a PDF and you select the mode of printing with the notes, then not only the slides themselves will appear, but also the notes. And under each slide, the answers of the different cases are already mentioned.
Okay.
So they are not on the slides, but they are under the slides, but not, of course, hidden when you present the slides themselves.
Okay, thank you. Yes, the slide deck so far, I have not shared it with our viewers. They will receive it, all the presentations after our webinar. They will be distributed to the EURES training coordinators who will then send it out to the rest of the network. Also, just perhaps two quick questions. There was a question whether Denmark has decided to sign the agreement and also Spain. If
Microphone.
Voilà, okay, I'll share with you now the full list as of today.
Okay.
So, first of all, 11 countries have effectively signed. What does it mean? Belgium is the depository state, and when a country signs, they should send to us the signed copy. So these are the ones absolutely, officially, finally in. There are 11 countries, being Germany, Switzerland, Liechtenstein, Czech Republic, Austria, the Netherlands, Slovak Republic, Belgium, Luxembourg, Finland, and Norway. Secondly, 7 countries have officially let us know they will sign. So this is not 100% in the pocket, but 99%. And these countries are Ireland, Malta, Lithuania, Hungary, Estonia, Portugal, and Poland. There is one state that has officially communicated that they will, at this time, not sign, which is the UK. Of course, for the UK specific situation, only people falling under the regulations through the withdrawal agreement, so I would say the old cases and still pending, can fall under it, because all the new situations fall under the trade and cooperation agreement between UK and European Union, and this piece of legislation does not have an exceptional article, so there is no legal basis. For everybody else, we did not receive an official point of view. So not from Spain, not from France, not from Italy, not from Denmark. So it is still waiting. Now, what does this mean in practice? This means the moment we receive the official yes before the end of the month, nothing happens. But as you've seen on the slides, if you are late, imagine we received a copy the 2nd of July. This means the agreement for that country, imagine France, will only be applicable as of the 1st of August. This means a gap of 1 month between the end of the transitional period and the beginning of the framework agreement. So let's give a practical example that you understand what this means. A person lives in the Alsace, so in France, and he has a German employer. And already for a year, this person works from home 2 days from home and 3 days at the office in Germany. No problem, we had the transition period and the German company pays Social Security in Germany. For the month of July, the normal rule applies, which means French Social Security, because this person works 40% in his state of residence, France, so French Social Security. From the 1st of August, the framework agreement applies. France and Germany. And the employer says, hey, I am going to submit a request to get German legislation, and he will get the agreement, which means there is a gap of 1 month. The only way to bridge this gap is for an individual classical Article 16 agreement, which means the German company has to ask it to Germany. Germany has to send the request to France, and France has to say yes and send it back to Germany. This takes weeks to months. So this means a mess, as they say in English. So we do hope that the member states willing to do so will effectively make up their mind and let us know before the end of the month that they will sign. Now, I've seen my Italian colleagues this week from the Istituto Nazionale della Previdenza Sociale who are in favor, and they are still going to push the ministry level and urge them, hey guys, if you want to sign, please do it before the end of the month. Otherwise, there will be some administrative mess. And France remains the question I get all the time. What about France? Well, there is a bit of an issue in France. That's all I can say, and I hope they make up their mind before the end of the month.
Okay, thank you. And there were some specific questions about the examples that you mentioned, but perhaps before we go into that, there was also an observation that this topic would be a good topic for EURES training. And for this, I have good news for our viewers. This topic is already in the EURES training catalog. It is a training that takes place once per year, if I'm not mistaken. The last training was this year in March in Athens. And actually, the expert trainer for the training is here with us, Gabrielle. You are the one who has been providing this training for quite a while. Could you perhaps quickly summarize what are the objectives of this EURES training?
Yeah, well, thank you very much for all the participants and all the follows. Yeah, right. This topic was really in the agenda of the EURES training, and thank you very much for the Bruno for a very deep insight, because now this European-wide framework is really the new thing that was now elaborated, and of course, this is something new that we have to take into consideration. Although at the beginning of this year there were already different agreements concluded between the member states in order to especially to explore and to protect those kind of remote workers or teleworkers, how we call them. And now we have reaching slightly, and well, we can say also slowly, but still we are moving to this European-wide agreement, which is a very good sign, especially for the for the teleworkers, because this question or questions concerning the remote workers or teleworkers have been asked already, not starting from the 2020 or 21, but even before that. Let's say there's 2018, 2019, what should we do? But before that, there's uncertainty due to the fact that the European Court of Justice has said, in case we talk about the free movement, that the free movement should be physically, which means the people really moving between the countries. Now, of course, we have to face the reality that the people are not moving between the countries. They're sitting in the countries and doing the same job, but also using the different means and possibilities. And of course, when we talk about the trainings in the future, especially that's connected to the EURES advisors, then of course, this topic will be in the agenda anyway, because when we are now approaching the signing by the all member states, I hope that all member states will be there, although the Estonia at the moment has not signed the agreement, but still thinking about it at least as a positive sign. Still, all other countries will be there, and this will be the, well, I could say, huge step concerning the protection of the remote workers within the European Union. Although we can speak about the social security issues or other issues that are connected to the taxation issues or other protection concerning the labor law are still on the table, but at least the social security, that is a very great movement. So that's why I could say that this topic will be included anyway, and we cannot avoid it. Because it's a remarkable sign in the European Union anyway. So that's all for my side.
Okay, thank you. I will perhaps now read out two questions that we have received via email, and they are actually specific questions that our EURES advisors are dealing with. So the first question is that the EURES advisors are in contact with an interim company that want to post a worker to Ibiza. It is about a Dutch worker living in the Netherlands. A Belgian company wants to post this worker in Spain, in the island of Ibiza. And how is the social security and taxation regulated? I don't know if Bruno or if Gabriel, you would like to take this question.
Well, I will leave the floor to first of all to Bruno, and then afterwards I will continue.
All right. So first of all, a general remark about temp work or interim. The temp agency is considered the juridical employer. So when we've been talking about employer, this is clearly the temp agency, not the client of the temp agency. That's, first of all, a very important point. Even if the client exercises the classical authority, the juridical employer is agreed. Secondly, a small point as well, watch out with temp agency work. Because in many states there is a very strict legislation about temp agency work where a specific license agreement or whatever is needed. So the first question, the first point, I always say, watch out if it is possible, legally accepted and correct that a temp agency sends workers to clients situated in another member state. So, but we suppose in this case that everything is okay, that it's a legit interim or temp agency, and that everything is okay. So we start with the first question. Are the European regulations on social security applicable? Yes, because Ibiza is part of Spain, so clearly fully a member state, and the company is Belgian, so I suppose the temp agency is Belgium. So we have a second cross-border element, and the worker is Dutch, so resides in the Netherlands, so we even have three cross-border elements. So, okay, regulations are applicable, which means this person is going to work only in Ibiza, Spain, which means the general rule would be that Spanish social security is applicable and that the Belgian temp agency must fulfill all the obligations of an employer imposed by Spanish legislation, meaning registering, paying contributions, etc. Except if the posting article is possible. So the posting article would mean you keep your habitual social security during a mission abroad. Temp agencies can post just as any other employer. This has been confirmed already in the 70s by one of the first cases of the European Court of Justice, the Manpower case. So in itself, that includes an agreement for a limited duration with the temp agency from to, and that during the whole period of this contract, a person is posted. This is possible, no objection. But let's have a look at the conditions. The first condition for a posting is that the person in the month, so the 30 days, immediately preceding the mission abroad, is covered in the social security scheme of the sending state from which he is posted. So in this case, this is not self-evident. It's a Dutch worker. So my first question would be, is this Dutch worker in the 30 days preceding his mission in Ibiza covered under the Belgian social security or not? It's possible. Eh? If it's yes, then it's probably very good. Because I suppose that the other conditions probably will be fulfilled. Being, is this temp agency a real company with economic activities for clients in Belgium and not just a posting company? Probably. Check. Okay. The authority link is very simple with temp agencies, where they're just paying the salary and the power to recruit and to fire the person. Temporary, of course, it's a temp agency by itself. And replacing an other worker, well, this will probably not the case. So my answer would be, if this person is covered under the Belgian Social Security in the 30 days before the posting, yes, it will be a posting. So the Belgian temp agency must request a so-called A1 document, applicable legislation, to us, National Social Security Office in Belgium. This can be done through the website www. And then in one word, social security, one word, .be. And there you have an online tool to request such an A1. If, however, the 30-day rule is not fulfilled, it will be absolutely mandatory Spanish social security. Now, the link with telework, whether this person is going to do manual work in Ibiza or is going to telework from Ibiza, makes no difference. Because then again, the Court of Justice has said, well, this telework, where is your place of work of a teleworker? It is the place from which you telework, so where you are physically present during your telework. Voilà, that was a bit of a long answer because it's not a straightforward question. It depends whether different elements in this case are fulfilled, yes or no. I'll be shorter for the next questions.
Okay, thank you. Gabriel, is there anything from your side?
Yes, well, I just will complete the answer from Bruno. As the lawyers usually say, it depends on, because we need to more information, we need to more details, and then we can say what's really happening. And when we come back to the taxation issues, then of course it is not linked to the habitual place of work, but it's basically saying habitual place of residence. So therefore we need to look where this residence is at the moment. And when we look now, according to the case study, that there's a Dutch worker living in Netherlands, then most probably the habitual place of living in that sense is the Netherlands, which means that worldwide income should be reported in Netherlands when he or she is now moving to Ibiza and to start to work there. Then we have to look whether this tax residence is really changed. Is it temporarily? in case it is posted just for, well, let's say 2 years, 24 months, which is allowed according to the European Union rules concerning the social security, then most probably the tax residence is not changing. But in case in this situation in the Ibiza, he has or she has to register the place where to live, it means that basically also tax residence will be changed, which means again, depending on the circumstances, we have two choices between the Dutch law or between the Spanish law where the taxes should be reported. So therefore, we need all the time the more information. So that's the end final outcome. Of course, I am sorry for the participants; they would like to have the very concrete answers, but at this time we need more information in order to clarify. And as Bruno also made very clear, it is not easy to say. It depends on the different circumstances. Thank you.
Okay, thank you. I see that we are slowly running out of time. There are still some questions in the chat connected to the specific examples, so I hope that our viewers would don't mind staying with us for 5 more minutes. So I will ask 1 or 2 more questions, but I would ask Bruna and Gabriel if you could always be concise. I know that perhaps it is not possible with the topic of the questions, but let's all try. So the second question is, there is a Dutch student who is studying in Belgium. The student is going to do an internship in Belgium with a specific learning goal and will receive 650 euros internship compensation per month. How is the social security and taxation regulated for this student?
Bruno, you can start first.
Also, perhaps, is it also a longer Bruno, your microphone?
So, if it's apparently it's clear that it's a classical internship, which means no Belgian social security. The person will not be considered as an employee of the company where the internship is in fact pursued, which means this will be a non-active person. And this means, in fact, that the legislation of the country of habitual residence, the Netherlands, will be competent. So this means health cover, etc., according to the legislation. If it is an internship in the context of an studies, higher studies, so this person follows higher studies and it's mandatory to do an internship in this context, then the Belgian legislation will impose on the institution where the studies are followed a mandatory cover for accidents at work. But anyway, on the 650 euros, no social security contributions will be needed, and the Dutch, neither the company, neither the client must register as an employer in Belgium.
Okay, thank you.
Okay,
yeah.
We'll continue now concerning the taxation issues. Well, it is not the same principle, but anyway, we have to look again at habitual place of residence, because the taxation, income tax, depends on the habitual place of residence. And of course, when we talk about this interim compensation monthly, then the question is whether it's equal to the wage, to the payment, what is now taxed according to the different laws. But anyway, in case this is the income that the person will receive now in Belgium, it still depends on the fact where is the tax resident. In case this internship will last for a temporary period of time, we do not know any details about that. Maybe it's 6 months. Then during the 6 months, basically saying the tax residence will not be changed, which means that it is still the Netherlands who have a right to claim all the possible taxation. In case this internship will last more than 6 months, then of course the situation can be changed. But of course, everything depends on, again, the typical lawyer's answer, depends on the double taxation treaty between the Netherlands and the Belgium. So unfortunately, there is no possibility to give this concrete answer how to divide. But anyway, let's say at least in case there is a Dutch student which is linked to the Netherlands still has a right, basically saying, generally speaking, demand a worldwide income, to report a worldwide income, and in Belgium, most probably, in case this international compensation is not taxed, the Belgium has no right to demand any taxes depending on the taxation law, but the Dutch legislation still has opportunity to ask everything, worldwide, what we are earning, not only in European Union, but outside the European Union, and report the taxes everywhere. So therefore, be aware that the Netherlands taxation authority will come to you and ask, what are you doing and how much money do you have at the moment?
Okay.
Thank you.
Thank you. One more quick question, and that is, how do regular business trips to the country of residence, respectively to the other EU states, challenge the application of the framework agreement with regard to Article 2, Paragraph 3 of the agreement? Or can this business trip be considered as posting according to Article 12? Is there...
Yes, an excellent question. And I say the case is simple. There is a difference between habitually, which means anticipated, planned, regular, part of your normal duties. And there is, on the other hand, occasional, exceptional, ad hoc. It's not planned. And this is the answer for many questions. So the framework agreement only applies if the habitual normal tasks are only in two member states, the member state of the statutory seat and the member state of residence. And in the member states of residence, you may only habitually telework. So, if besides the work in the member state of the employer and the telework in the member state of residence, anything habitual happens, it's finished. Everything occasional does not endanger the framework agreement. An example, you have some conferences to attend, 2, 3, 4 a year, whether they are in the member state of residence or they take place in other member states, no problem. If it's another member state, it's posting. If it's your member state of residence, you don't have to do anything. If beside the telework from Belgium, you also do workation from a holiday home in Spain 2 times a year, no problem. Everything anticipated. So your question, Eva, is also the answer. It is the facts. If you know in advance it's a normal part of your working pattern, then there is a red flag. If you know it is occasional, then this is possible for many cases. So, of course, how do we check it is then the question. How do we know this? Of course, we as a government, we know everything.
Okay, good. Thank you. Then there were also a few questions with regard to one specific example in your presentation, Bruno, but I see that we are going quite a lot over. So perhaps, Bruno, I would reach out to you via email and you could provide your input in writing, which would then be disseminated. Also, you already mentioned that in the slide deck, the answers to the examples are included. Before I thank everyone, I also wanted to ask one question to Oscar, who has been with us as well. And that is, Oscar, I know when we have been preparing this for this webinar, you have mentioned that Eurofound has a podcast. Could you please say a few words about this podcast? Because I think that it's something that our viewers could find it quite interesting. You are muted.
So thank you, Eva, for the question.
Eurofound produces regularly some podcasts on specific aspects of working conditions, living conditions, and industrial relations. One of these podcasts was about telework. This is in Spotify, also in our website. Covers, it's an interview where many aspects of working conditions related to telework are addressed. So I invite you, the audience, to visit our website and look for podcasts, and there you will find, this podcast on telework.
Okay, thank you very much. And I would also like to take this opportunity to thank all three of you for your very knowledgeable input and very interesting input. I know we are a bit pressed for time, so unfortunately we couldn't go into everything in detail. Nonetheless, I hope our viewers have enjoyed it. For our viewers, thank you for your attention and for staying with us even after the webinar was supposed to finish. I am pasting now into the comments a link to a satisfaction questionnaire that I would like to ask you to fill in, to provide your feedback so that we can continue to improve our webinars. At the same time, as mentioned before, in case you have any other questions, please feel free to reach out to the EURES training provider so that we may answer more of your questions. And also all the slides that you have seen in the webinar will be shared with the training coordinators. The recording of this webinar will also be available, but first it will undergo a quality assessment by the EURES training provider and also by the European Coordination Office. So thank you very much, all of you, and I hope you have a nice rest of Friday and a nice weekend.
Thank you.